Welcome everyone. We've got a wonderful member presentation today from Sian Dyce, who's an elder mediator and also a family dispute resolution practitioner, and she's going to reflect and share with us on the differences and the nuances of the two different areas of practice.
And I can't say I've got all the answers, but very happy to start the conversation.
Wonderful. Well, I will hand over to you.
Fantastic.
Thank you. And I didn't really thank you effusively, which I want to, because it's really important for practitioners to share their insights and experience. And I really am grateful you start the year off for us.
Well, thanks very much, Joanne and Mediation Institute. I'm very excited to be talking about my two favourite topics, the differences between family dispute resolution and elder mediation. So before we begin, I'd just like to start with an acknowledgement of country. I'd like to acknowledge the traditional custodians of the lands, waters, seas, and air on which we all live. Today, I speak from Sydney's inner west on the lands of the Wongal clan, part of 29 tribes of the Eora Nation. I acknowledge the strength, wisdom, and cultural knowledge of Aboriginal and Torres Strait Islander elders, past, present, and emerging. And in the spirit of reconciliation, I also acknowledge the generosity shown by Aboriginal and Torres Strait Islander people to those of us who've journeyed from other lands to make a home in Australia. So thank you very much for joining me. I am Sian Dyce and I'm the founder of Family Talks, and I'm a family and elder mediator. I have lots of experience in family dispute resolution, and I'm a very keen, newly qualified elder mediator, but it's my area of passion. So I'm here today to share knowledge and, as I said before, open the conversation to all of us. But I certainly don't have all the answers, but I have lots of thoughts. The differences between family dispute resolution and elder mediation. Today, I'm going to look at 7 main areas. First of all, the definitions, then the participants, the timing, guiding principles, ethical issues, implicit biases, and legal status. So first of all, definitions. What is family dispute resolution? I know most of us know this already, but for clarity, it helps separating families agree on parenting and/or property arrangements. It aims to help families develop their own parenting plans that focus on the needs of their children. Now, as we know, property can also be done with couples who are separating that don't have children. For the purposes of today, I'm going to be referring to family dispute resolution in that parenting specific context. So again, what is family dispute resolution? The Attorney General's Department says that it's a type of mediation that helps separating families reach their own agreements. During family dispute resolution, families will discuss the issues in dispute and consider different options. If a family is affected by separation and has a dispute about the care of children, the law requires them to make a genuine effort to sort it out through FDR before filing an application for parenting orders in court. And as we said before, we can also help separating families work out their property arrangements. So the Family Law Act focuses on the rights of children and the responsibilities of each parent. And I know that many of us have that conversation with our clients, who has the rights and who has the responsibilities. So what is elder mediation? Elder mediation guides families through important conversations around aging. Like family dispute resolution, it facilitates respectful, collaborative conversations within families, but this time they're discussing aging and future needs and wishes. So, elder mediation is a focused, respectful process, usually multi-party, multi-issue, and intergenerational, whereby a trained elder mediator facilitates discussions focusing on present strengths and assists participant in exploring any issues or concerns to enhance the quality of life and the wellness of the older persons while respecting the needs of each participant. And this is from the International Mediation International Network, IMIN, and their Code of Ethics, which I'll be referring to throughout this presentation. So elder mediation is based on a wellness model that promotes a person-centered approach for all participants. It's mindful of the older persons while respecting the rights of each person participating. So who are our participants in both these forms of mediation? So in family dispute resolution, we have parents, we can have grandparents, and very significantly, we can have any other person concerned with the care, welfare, or development of the child, and that's from Section 65C of the Family Law Act. Now, the participants in family dispute resolution can be determined by what we call a child's best interests. So Section 60CC talks about the benefit of the child of being able to have a relationship with the child's parents and other people who are significant to the child where it's safe to do so. And it also, the Family Law Act also asks us to consider anything else that's relevant to the particular circumstances of the child. Now, the Family Law Council back in, I think, 2013, provided a report on parentage and the Family Law Act to try to take into account the new versions of families we have at the moment, blended families, kinship care arrangements, the rise in IVF and blended families, etc. So they were encouraging changes to the Family Law Act to determine what parentage really means. The Family Law Act, in response, kind of strengthened a vague but very open understanding of parents. So the family dispute resolution is usually two parties representing parents, and as we've seen, in the broadest sense of the word. So that could include step parents, for example. Whereas participants in elder mediation, my chair's moving backwards as I speak, can include the older person's partner, sibling, friend, adult children, maybe adult children's partners, but it can also and significantly include neighbours, if they're relevant, care workers, and as well as professional advisors. So it could include lawyers, accountants, sometimes even doctors, depending on the needs of the older person. So the Emmett Code of Ethics mentions that the form of mediation involves many people related to the issues. So that can include, as we said, family members, caregivers, organisations, agencies, and a variety of service providers and networks. So if we just do a very quick comparison, family dispute resolution, we have two parties, elder, multi-parties. Family dispute resolution is usually a single issue. We're looking at parenting or property. But elder mediation can include, and usually does, multiple issues around aging. The goal of family dispute resolution is to reach agreements that are in the best interests of the child. The goal of elder mediation is to enhance the quality of life and wellness of the older persons. So quite different goals there. So another really interesting thing about elder mediation, which I've alluded to earlier, is that it's collaborative, and collaborative in the truest sense of the word. So it actually encourages the use of other services and people within the mediation itself. So people that could be part of a mediation could be advocates, lawyers, counsellors, support people, and including those who may be assisting with supported decision makers. And if we really can't avoid it, then those people who are deemed substitute decision makers. With family dispute resolution, we know that the role of the support people is very strictly determined. In FDR, support people are not to speak on behalf of the participants. They're not to ask questions directly. It is definitely the two parties themselves that are speaking and participating in family dispute resolution. And that's the case even where we have lawyer-assisted mediation. It's still the two main parties who are speaking to each other. The exception to that is with a child inclusive practitioner. That's when we might bring a child practitioner into the mediation space, but that is kind of a rare, increasingly being used, but it's there doesn't seem to be any other professional experts that we bring into family dispute resolution, which is not the case in elder. We bring in whoever is relevant to assist the older person and their family. Where we do have similarities, both family dispute resolution and elder mediation are voluntary, confidential, and non-binding, and they're both designed to support families to find their own solutions. So let's have a look at timing and when we can use these two forms of mediation. So family dispute resolution, I'm going to use the word crisis here, so excuse the sort of clunky word, but family dispute resolution is always after the separation. So after some form of crisis, for want of a better word. However, one of the huge benefits and I think strengths of elder mediation is that it can be used pre-crisis, for want of a better word. We can use it in the planning stages. We can use it before there's any need for any changes or intervention. We can also use it during those changes or transformations within a family and the life of an older person. And also, to be really frank, we can use it after somebody has died or after somebody has made a major transition, for example, into an aged care facility. So elder mediation can be used at any point of the family's life, whereas family dispute resolution is really limited to post-separation. So if we just dig into this a little bit more, if we look at what I'm calling pre-crisis, which, as I said, is a bit clunky, but one of the great strengths of elder mediation is that it can be used to prevent conflict or distress before it even starts. It can be applied along what is called the continuum of conflict, including to any prior conflict developing. So it's preventative. And it's a huge opportunity to use mediation, elder mediation, to plan for the future in advance of any need. The other thing about elder mediation is that it's proactive. So it's designed to center the voice of the older person at the heart of all conversations, and the older person's needs and wishes are the paramount consideration. Now, this is absolutely different to family dispute resolution, where we do speak of the needs of the child and the best interests of the child. However, at the end of the day, it is the parents who decide what those best interests, needs, and wishes are. Whereas in elder mediation, it is the older person themselves who determines what their needs and wishes are. The other thing is that elder mediation is protective. So one of the aims is to empower the older person to have their voice heard and respected, directly and indirectly. And agreements can ensure that the older person's wishes and views are known and applied, even if they become unable to express them later on. So again, this can be used post any kind of crisis, particularly a health crisis. Even if the person becomes unable to communicate at a particular point in time, if they've been able to express these views and wishes and they've been recorded, then that can protect those views and wishes going forward into the future, because family knows, and by family I mean, again, the broadest sense of the word family, all interested parties and supporters of the older person. Family knows what those wishes are, even when the older person may not be able to express them at the time. So what are some of the guiding principles if we have a look at the differences? So with family dispute resolution, we know that high levels of conflict between parents places children at greater risk of developing emotional, social, and behavioural problems, as well as having difficulties with concentration and educational achievement. This is from the Federal Circuit and Family Court of Australia. So one of the major goals of family dispute resolution is to reduce the conflict between parents, to support the parents to foster greater communication and co-parenting skills, and thereby enhance the lives of the children who are impacted by conflict. As we know, it's not the separation necessarily that causes distress for children, it's the conflict surrounding the separation, and especially if that conflict continues during the co-parenting journey. So that's a very sort of significant and very focused goal of family dispute resolution. Elder mediation, those goals have sort of a different focus, because elder mediation can reduce the overall stress in family systems, and it has been shown to have a health and wellness implication, enhancing the functionality of the family support network, heightening interpersonal communications, and significantly, often delaying the need for institutional care. So one of the major aims of elder mediation is not to stop institutional care if that's what the older person wants or requires. It is about supporting them to live the life that they want for as long as possible, and working out what supports are needed to enable that to happen. So if we have a look at what the rights of the child are, in family dispute resolution, we're guided by the UN Convention on the Rights of the Child, which, to name just a few, includes the right to live a full life, that children should not be separated from their parents unless it's for their own good, that children have a right to good quality healthcare, clean water, nutritious food, and a clean environment, and that children have a right to an education. There's 42 rights. These are just some of them. But in the Family Law Act, we see that they describe the best interests of the child, which mirror the rights of the child, the UN Convention. And in fact, the Family Law Act actually states that it's to support the UN Convention on the Rights of the Child as well. So some of those considerations for what's in the child's best interest include what would promote the safety of the child and each person who has care of the child, any views expressed by the child, the developmental, psychological, emotional, and cultural needs of the child, the capacity of each person who has parental responsibility, the benefit of a child of being able to have a relationship with both the child's parents and, there again, or other people who are significant to the child where it's safe to do so, and anything relevant to the particular circumstances of the child. It's very important that the best interests of the child under the Family Law Act also take into account a history of family violence and the rights of a child to enjoy Aboriginal or Torres Strait Islander culture where appropriate. So what we see is that children have rights, parents have responsibilities, but while the best interests include, under the Family Law Act, the views expressed by the child, as I mentioned before, ultimately it is up to the court and or the parents to determine what is the best interest of the child and how to weight those views. The Family Law Act, while trying to be child-centred, ultimately does make decisions for and about children. In elder mediation, what are the rights of the older person? Again, we can turn to the UN principles of the older person, and they're based on 5 key areas: independence, participation, care, self-fulfillment, and dignity. Our new Aged Care Act Statement of Rights ensures that older people can make their own decisions about their own life, have these decisions not just accepted, but respected, get information and support to help make their own decisions, communicate their wishes and needs and preferences, feel safe and respected, have their culture and identity respected, and stay connected within their community. So what's exciting about the new Aged Care Act is that these rights also confer a positive obligation on service providers, and indeed all of us, to ensure that the rights of older people are upheld. So it's not just enough to know these rights, there's actually an obligation for us all to help enforce these rights by actually supporting the older person to have their decisions, for example, respected and to make their own decisions. Part of the role of an elder mediator is to help educate the older person and their family members about these rights. There's also, in terms of support, there's a new concept in the New Aged Care Act that has created something called a registered supporter within aged care. And that can be someone the older person trusts, like a family member or friend. And their role is, again, not to speak on behalf, as in not to make decisions for the older person, but to perhaps speak on behalf of or support the older person to say what it is that they want, their own decisions, help them communicate their own decisions about their care needs. The registered supporters are different from aged care advocates, which can be supplied by OPAN, fabulous organisation. An advocate role is slightly different to a new supporter role. An advocate is an independent person, so it's not necessarily somebody who the older person already knows and trusts, but they're there to listen to the older person's concerns and to provide them with information. And they can, for example, help the older person make a complaint. So a really big concept in elder mediation, and indeed the New Aged Care Act, is something that is referred to as the dignity of risk, which is basically, as we've been saying, that a person has a right to make their own choices regarding their lives, but significantly, even if those choices involve risk. So unlike a child under the Family Law Act, the goal is to create an environment for a child that is safe and enhances their well-being. Within the New Aged Care Act, this concept of dignity of risk aims to, and elder mediation in general, aims to increase an older person's well-being while acknowledging that what an older person considers essential to their well-being may, in some cases, actually put them in harm's way. For example, somebody may want to remain living at home when they are losing some of their abilities to participate in their tasks of daily living. However, the dignity of risks means that if that is their choice and their preference, then even though it may involve risk, that is their choice. So if we have a look at, just have a little drink for a second. I don't know if you can see, but I have a gnat flying around and I'm hoping I won't inhale it in the middle of this. Okay, so if we sort of just look at a kind of quick sort of comparison of what we've been talking about, the guiding principles of family dispute resolution, we see the subject is the child. For elder mediation, the subject is the older person. The focus for FDR is the best interest of the child. The focus for elder mediation is the wishes and preferences of the older person. When it comes down to it, decision-making within FDR is by others for and about the child. However, decision-making within elder mediation is by the older person for themselves. Where there's some similarities, FDR and elder mediators both are specially trained with in-depth knowledge of their fields. They both must not provide any expert advice. If they're lawyers, they can't provide legal advice or financial or counselling or psychological advice. Both are impartial and non-judgmental and will not tell anyone what to do or push you to make agreements. If we sort of focus on the voice at the centre of both these mediations, again, family dispute resolution, it's the child. Now, the approach of family dispute resolution is traditionally child-focused, but it's listening to FRSA and a lot of attempts by the family FCOA. There's certainly a push to move much more towards child inclusive, in other words, to try and bring the child in some form into those conversations. So it is trying to be much more child inclusive, but at this point, I would suggest that it's still relatively child focused with other people ultimately making decisions on the child's behalf. The mediator's role is to work with parents to assist them to reach agreements regarding parenting arrangements. And we may have a child inclusive practitioner who may meet with the child. In elder mediation, we've got the older person, and the approach here is to protect the rights, safety, and interests of the older person. And the mediator's role is quite different to that of an FDR. It's to ensure that the voice of the older person is heard directly or indirectly and respected. And really importantly, this applies to older people with and without what we call capacity. I think this kind of role of the elder mediator raises some really interesting / very tricky ethical issues, which is why we're going to ethical issues now. And specifically, I'm really interested in how we look at the balance of power within the elder mediation context, especially when you compare it to FDR. So I just want to go now to the FDR regulations from 2025. As we know, as FDRPs, a big part of our role is to work out, is dispute resolution appropriate? And the kind of things that we sometimes take into consideration are, is there an equality of bargaining power amongst the parties? What's the emotional, psychological, and physical health of the parties? And are there any undue bias, or is there an influence of a person, whether or not that person's party to a dispute, on the parties? These and others, as you know, are some of the decisions we have to think about when we're working out, is FDR appropriate for now? And we work hard, as you know, to really try and get an equality of bargaining power when it comes to FDR mediation. So we might use shuttle, we might use support people, we might use legally assisted mediation to try and balance power in the room. And likewise, when we're thinking about whether FDR is appropriate, we're really asking, is FDR appropriate right now? Can the parties, do they have equality of bargaining power now? What's their emotional, psychological health like as we speak? It's a point in time decision. And that's why, as we know, the certificate 60Is are valid only for 12 months because the court recognises things can change. All these questions can shift. So it's a very much a point in time decision. However, if we go and think about elder mediation, I would argue that the conditions that might make FDR unsuitable are often present during elder mediation. So I'll just explore this with a case study, and I'll just have a quick sip as well. So if we look at Barb, let's say Barb's 76, and Barb's been diagnosed with Lewy body dementia. This means that her cognition fluctuates. Sometimes she's her usual sharp self, and sometimes she mistakes who she's talking to, and she loses her sense of time and place, and even sometimes her personal history. And other times she's sharp as a tack. It fluctuates, it goes back and forth. Let's say that Barb lives with her son Ben, 42, who's her primary carer. Now, Ben has been living in the family home with Barb all his adult life, so he hasn't ever moved out of home. Barb has a couple of other daughters, and they are concerned about the progression of Barb's Lewy body's dementia, and they don't feel that at the moment Ben is providing adequate personal care for Barb. So, for example, her showering, her hygiene, making sure she's eating properly, taking her medications. So they're very keen for Barb to move into an aged care facility because they're like, she needs to have all these things in place to be really well looked after. However, if Barb was going to move into an aged care facility, the family home would need to be sold in order to afford it. Now, Ben doesn't want her to move out of the house, which is also his home for his entire adult life, and he would like to continue to care for her. There's your case study. So let's just backtrack, just holding that in our minds, all those issues. Let's backtrack to what we would consider, some of the things we consider in FDR. So is there an equality of bargaining power? What's the emotional, psychological, physical health of Barb, of Ben, of the daughters? And is there an undue bias or an influence of a person, hint, hint, Ben, and or the daughters who want to sell the family home? So how is that playing out in elder mediation? I would argue that that case study, which is really pretty typical of elder mediation, ticks all the boxes that in FDR would deem it inappropriate. And where that's the starting point often for elder mediation. Not that exact example, but all sorts of complex ethical issues and decisions that need to be made. So as I've said here, conditions that may make family dispute resolution unsuitable are often present during elder mediation. So we looked at the case study and just sort of reflecting that older people may, not always, may have a range of health or cognitive issues that may impact on their ability to participate in elder mediation. So, as mediators, how do we address this balance of power issues and how do we maintain mediator neutrality? It's a really big question, and especially when we look at one of the goals of elder mediation is for the mediator to support the older person to express their views and have those views respected. So what does this mean for neutrality? How do we maintain neutrality while also supporting the older person and their rights? Just want to mention I'm asking these big questions. I certainly do not suggest that I have the answer or that there is only one answer. These are just fascinating questions for me and all of us in elder mediation. So I'm just wanting to pose them here for all of us to have a big think about and come up with different ideas. I have some thoughts, of course, so I'm going to suggest those, but by no means is this the answer. So how are we, so just a refresher, what we're looking at is how do we balance power and how do we maintain neutrality as a mediator in elder mediation? So here's one answer, not just my answer. It's one of many, but it really revolves around, I think, changing our concept of the mediation process. So family dispute resolution is usually a one-off event. It's a mediation in time at that moment. We may have follow-up mediations, but generally it's a one-off event. And we're making decisions on that basis, usually about whether it's suitable. However, elder mediation needs to be seen as an ongoing process. It isn't necessarily possible to address all these big questions of capacity and or balance of power in one moment. Elder mediation is an ongoing process. There are often multiple shorter meetings and or adjustments and changes along the way. We need to make sure we realize that it's very rarely going to be solved in one 3-hour session, for example. And if there's a vulnerable older person, 3 hours is unlikely anyway, usually aiming for sort of 1.5 to 2 hours, depending on everybody's capacity. Most importantly, the older person, excuse me. So just to summarize, elder mediation is a process, not an event. The mediator, part of their role is to create conditions and opportunities for the older person to communicate their wishes and preferences. And how they communicate those wishes and preferences may need creativity, and it may not be directly always the older person themselves in the room. And that's where the use of support people, external professional supports, becomes even more relevant. So if I was to summarize kind of again the differences and some of those ethical issues, so I think sort of we can say that family dispute resolution kind of asks the questions, are the parties able to mediate now? And in that way, I see that in a way that the parties need to demonstrate to the mediator, the FDRP, that they have capacity. They need to, that's part of what we do in our assessments. Does this person have capacity to mediate now? However, for elder mediation, I think what we're really asking is, what needs to be in place? What do we need to do or change or support for the older person and relevant other people to be able to mediate now? So we're assuming that the older person has capacity. It's the elder mediation itself that may need to adjust to support the capacity of the older person, which I think is really interesting. Really fabulous kind of opportunities for mediators to really expand and explore and test their skills. But it's also terrifying, to be honest, because how can we're really challenged, I think, as elder mediators to make sure we're maintaining this neutrality while also supporting the older person. I think it's very exciting, but it's certainly challenging. To help us, we can have a look at the role of the elder mediator in safeguarding vulnerable adults. And this is a document put together by EMIN, the Elder Mediation International Network. And it helps give some guidelines to elder mediators to how to address some of these questions and what their roles and responsibilities are. And it's very helpful. So, for example, they talk about Safeguarding Vulnerable Adults document, which is used in conjunction with the Code of Ethics, talks about the role of the mediator to actively promote the dignity and quality of life and the human and civil rights of the vulnerable adult. So again, that's really interesting when you're looking at it from an FDR perspective, because we're not, as FDRPs, promoting necessarily the human and civil rights of the parent, but rather the child who isn't present in the mediation. Whereas in elder mediation, the older person is present. So how do you maintain neutrality? There's also a responsibility on elder mediators to embed preventative measures and strategies in the elder mediation process to safeguard vulnerable adults from future abuse and abusive practices. Similar to FDR, when we're looking at the impact of family and domestic violence and history and risks, etc. Okay, the other really useful concept in safeguarding vulnerable adults, EMIN, is self-determination, which we keep talking about, but it is such an important factor in elder mediation, and that is that vulnerable adults have the right to make decisions, including choices that others might consider risky or unwise. And here again is this statement: the elder mediator must find appropriate ways to include the voice of the vulnerable adult in any decisions that may impact them. And again, that's from EMIN. So we've got, again, a positive obligation on elder mediators to support the older person. I'll be going for time. Okay. This brings us to another really important area in elder mediation, and that's capacity. So this is care of the fabulous Professor Dale Bagshaw, who, oh, why have I lost that heading? Capacity, who, oh, sorry, not this one, the next slide. I'll get to that. So in elder mediation, capacity is assumed, including for those with forms of dementia. So just because somebody has dementia, it doesn't mean that they're unable to make decisions. The other thing is capacity can fluctuate depending on the time and context and current state. Capacity is decision specific and time specific. There are 3 types of capacity in Australia. We look at legal, mental, and physical. And New South Wales Law Society has a fantastic document that this is from about how to look at capacity. Now, crucially, an older person may not have legal or physical capacity in a legal sense. In other words, perhaps a lawyer may not deem that they have legal capacity to make a will or to make guardianship decisions. But within elder mediation, they still may have capacity, mental capacity, to very clearly express their views and their preferences. So a question we can ask as elder mediators is, does this person understand consequences and can they communicate them somehow? Now, how they communicate them may be very different to somebody without a form of dementia or an illness. But people can communicate in all sorts of ways and make their views pretty clear. It doesn't always have to be in full sentences. So what we're looking for as elder mediators is, how does this person communicate, for a start, and can we understand them, and do they understand the consequences? So this is the very useful suggestions from Professor Dale Bagshaw. This is from the Elder Mediation training. She's, if you haven't already met Professor Bagshaw, she is the leader of EMAN, which is the Elder Mediation Australasian Network, absolute sort of pioneer of both FDR and elder mediation in Australia. And if you haven't already done her training course on elder mediation, you definitely should. Even if you're not interested in elder mediation, it's an absolutely fantastic course. Go to EMAN for more information. But what Dale has proposed, the way that we can enhance capacity within elder mediation, is to ask whether the older person needs to be present for all or part of the sessions, which again is pretty challenging, I find, for an FDRP. What do you mean the person's not going to be there? But they were there the last one. Can I still mediate if not every single person is still in this mediation? We'll get to some of those questions, but it's challenging, I find. Also, the mediator can, and their mediation skills can enhance capacity of the older person. Do they need a support person? Let's have a think about the time of day. When is an older person at their strongest, most energized, most coherent? Where are we having the mediation? Does it need to be in the person's residence? And if people are remote, the older person is the person who's in the room with the elder mediator, for example, and everybody else dials in potentially. Can we use, or is there a registered supporter? Is there already somebody that the older person would like to be a surrogate for them in a mediation, who knows their views and wishes? And also, just like with FDR, we do need to think about safety planning and whether we need to involve protective services. Unfortunately and devastatingly, family and domestic violence continues right throughout someone's entire, may continue throughout someone's entire lifespan, including family. We don't necessarily age out of conflict or out of family and domestic violence. So it's really important to also have safety planning in the back of our minds when we're looking at whether or not to do elder mediation and or how someone can mediate effectively. So I'll leave you with all those thoughts. Don't have answers at the moment, but some other ethical challenges that I think are really fascinating from an elder mediation perspective is who pays. It's very clear in FDR. We always like to make sure that both parties are paying for their proportion. We know that money equals power, but what about when there's two parties? It's pretty straightforward. But what about in a family? Who should pay? Is it the older person? What if one person, like the oldest child, for example, or the most successful child, pays for the whole thing and then decides they don't want to participate on the second or third mediation? How do you fairly sort of break down costs, especially if it's a process? Yeah, I don't have the answers. It's a big challenge. Who participates? Oh, sorry, I've just skipped ahead. With just like with FDR, who is appropriate to be in the room for elder mediation? What's the history with all the participants? Is the sister-in-law going to antagonize the mother-in-law? All of those questions. Is the person who's been potentially designated the guardian, maybe somebody has guardianship of an older person, does that necessarily mean that they are the best substitute or supported decision maker? Lots of questions, all case by case basis. Excuse me. As I said before, what does everyone have to participate in every mediation or mediation meeting or not? And if they don't, what does that mean? What does it mean for confidentiality? How is it communicated? What was agreed in each meeting? Again, what are the limits of confidentiality? And also some of the ethical challenges, not just for the family, but also for the mediator themselves, is where the dignity of risk contradicts or comes in contradiction to somebody's safety. As we know, mediators have come with our own sets of values and personal beliefs. Really important that we know those and are self-aware, because especially with elder mediation, often we're dealing with questions around dying, death, palliative care, perhaps voluntary assisted dying, people's choices around where they do and don't want to live, etc. We're going to have our own opinions about that, of course. Really important that we interrogate those when we're working with families to make sure that we're not accidentally um, uh, bringing those to the table as well. Um, yeah, so big challenges, no answers here, but lots of thoughts. Okay, so I've got a case study. I actually think we've got 10 minutes, so I'm just going to skip this one. But it was basically looking at, again, that dignity of risk versus personal safety and how challenging it is for families as well as mediators when a family member, an older person, may decide to stop supportive treatment or not receive external care supports, or even perhaps if we're talking about wills, what the older person's choice is around dividing their estate and assets. And that can be incredibly challenging, of course, for some family members. But at the end of the day, it's the older person's decision and the older person's preferences that are paramount. So I'll skip that case study. Okay, so if we look at some of our implicit biases, so again, a really big one in elder mediation is ageism. It doesn't come into often, it might in grandparenting, but it's not usually such a big one within family dispute resolution. Part of our role, again, with this EMIN Safeguarding Vulnerable Adults as elder mediators is to counter ageism by modelling respect, inclusion, and equality, and ensuring the voice of the older person is heard and respected. Some other um, uh, implicit biases that we have we come across both within ourselves and with our participants in family dispute resolution and elder mediation is caring roles. So FDR might be around what our assumptions are around the care of children. And in elder mediation, we also need to interrogate what are our assumptions around the care of older adults, i.e. who does it, whether that's us or the family members or the older person themselves. Having assumptions around that. Now, it's just because it's a bias doesn't mean it's wrong. So there might, as we know, there might be an assumption that, for example, the oldest daughter is the person that organises care of the older adult. It's not necessary for the mediator to somehow counter that bias if that's what the family and the older person and the oldest female child want. But what our role is as elder mediators is to bring those biases to the surface. Is that an acceptable mode of operating? Is everyone happy with that or not? So just because it's a bias doesn't mean it's wrong. We're just wanting to bring what's hidden to the surface. This is particularly important, I think, when it comes to caring, because we know that carers are usually female and informal carers of older people provide on average, I never get over this, 98 hours a week for 9 years. So informal meaning they're not paid, and usually often have work and other caring responsibilities. So yeah, I could talk at length about the impact of caring, as you can see there. So some of our other biases in FDR might be what are the roles of a mother, a father, and in elder mediation, it might be what's our family role? Who's the golden child? Who's the black sheep? Who do we automatically assume should be the guardian or look after the money if it was power of attorney? So again, just bringing some of these assumptions out into the open. Nothing has to change. That's up to the family and the older person themselves, how they want to organise their family unit. It's just important that people become aware of these underlying assumptions if it's not what they've chosen and if they're not happy with it. Okay, again, needing to look at cultural expectations. What's the grandparents' role? Are there financial obligations? What languages are we learning in the home? And our religious expectations, particularly around death and dying, marriage and divorce. These are just some examples. Okay, family roles, cultural expectations. Okay, so got 5 minutes. I'm just going to whiz through the legal status between FDR and Elder. As we know, family dispute resolution is kind of governed by the Family Law Act and the FDRP regs. And also in various states and territories, it includes things like we need to be aware of child protection laws, crimes acts, including family and domestic violence, coercive control, privacy laws, data collection. So FDRP and the mediation process is confidential and very happily inadmissible in court. However, this is not the case for elder mediation. Elder mediation doesn't have those same built-in protections. Very sadly, I think Professor Bagshaw's advocating and has been advocating to change that, and hopefully we'll see some movement there. But currently, elder mediation is not kind of governed by any particular specific legislation in the same way FDR is within family law. So some of the acts that are relevant for elder mediation include, these are just, this is not all inclusive, but this is sort of the main ones. The New Aged Care Act. Federally, we need to also look at the Anti-Discrimination Act, Australian consumer law for how we conduct our mediation practice, and significantly what common law says around advance care directives. So this is under federal legislation. Some states, for example, New South Wales, don't have any statutes around advance care directives, whereas other states do. So you need to be really aware of that in your own state and territory. And if you don't have a state or territory statute, then you come back to the federal common law around advance care directives. Family Law Act often, particularly around grandparenting, might come into play. Privacy Act. So there's some of the laws for elder mediation federally. And for state and territory, again, we need to be aware of our own jurisdictions for crimes, personal, domestic violence, and power of attorney, enduring power of attorney. Each state and territory calls it slightly different things and have slightly different, helpfully, regulations and rules around it. Same with guardianship and enduring guardianship. So you've got to be really across that wherever you're working. We also need to be aware of the anti-discrimination law, privacy and personal information protection, and as I've mentioned here, not all, New South Wales doesn't have an advance care directive statute, and not everybody does. So just make sure you do your own research on that, and this is not an exhaustive list. So I stand to add things if anybody has any other things they'd like to add. But also what it means is, in terms of how elder mediation is governed, ultimately, as we know, if parents can't make agreements, they do have the option to go to the FCOA. But for elder mediation, where do they go if they can't reach agreements? Well, it's vexed, and there's not a clear-cut direction for people. If it's around guardianship, then many state and territories have administrative tribunals. So NCAT in New South Wales that deals with guardianship specifically. There's also the state, I've forgotten what they're called, but they do the finances state. I'm sure you all know, but there's state and territories have their own gut body, like tribunals that will determine financial decisions as well. But sometimes things like wills and estates, it does a kind of, if it can't be resolved, then people do end up going to court over that sort of thing. We just don't have a clear-cut way of moving forward if agreements can't be reached. Okay, I think we've got 1 minute to go, and we are at the end. So hopefully that's been useful. As I said, it's the start of the conversation, and I hope it's given you a taste of the differences. And apologies that we didn't get to any questions, but perhaps, Jo, you could...
What I've been doing in the background, because you've raised so many amazing, interesting questions, is I've created a group for elder mediation in my network. I'll pop a link in. If everyone's comfortable, I can put the questions into that group and you can kind of engage with them there, and perhaps we can schedule a time just to have a conversation about all of this once you've had a chance to probably review the presentation again because it was that good. I think you've done a beautiful job.
Thank you.
Does that? And the network's open to anyone. So our guests that are here that aren't Mediation Institute members, you're welcome to come along as well.
And yeah, just to reiterate, I'm by no means the expert, but I'm absolutely fascinated, in case you couldn't tell by Elder, just at the beginning of my journey with this, and just very keen to continue sharing our thoughts and some of these big challenges we've got.
Yeah, no, absolutely. Yes. But any 5 minutes, second comments, thoughts? We don't have time for questions, but probably just sharing my thought. That was such a beautifully put together and knowledge rich, content rich presentation that it's I really do want to put it up as a resource into this group. So yeah.
Great.
And also a reminder to people that elder mediation is really a specialist area. As things mature, I'm sure there'll be legislation around it, but at the moment it's part of the AMDRAS standards as a recognised specialisation. So, it's not an area to jump in feet first without a good, very good, solid background and understanding of capacity, elder abuse, the various many conflicting and crossing over legislations and factors to take into account. Would you agree?
Oh, yeah. And I feel like the more you learn, because I've needed to really dive into this to get my advanced certification through EMIN, but the more I read, the more questions I have, and the more exciting, but the grayer and the sometimes
Yeah.
very daunting to me it becomes.
Yeah.
But
And I think it's really prompted for me that we need to create this community. So if you are working on a case, you can pop into a brains trust and even just bounce it off someone who understands. So you're not out doing this very challenging, very, very important work without support. So thank you. Thank you so much.